Good afternoon, everybody, and welcome. Thank you so much for joining us at our Food Focused Legal Eagle webinar. And we're really delighted to have Janusz Luterek with us again. For those of you that aren't familiar with Janusz, you need to know that he holds degrees in chemical engineering, as well as being a registered attorney, patent attorney, and he's a registered professional engineer. He's a partner at Hahn & Hahn Attorneys, which is a boutique law firm founded in 1951. He's a custodian member of SAFAST. He sits on the council for the FSI in South Africa, as well as sitting on the Food Law Advisory Group of the Department of Health. So Janusz is well connected, definitely the right person to have discussing this interesting topic today with regards to pseudoscience and protecting the consumer. Janusz qualified as an attorney. He then worked at the CSIR, where he was specifically involved in engineering in the brewing sector. He then worked as a senior process engineer at AT International, so he's got his hands dirty as well. So he has some understanding for the challenge in the industry. Talking about the topic he recently presented on at the conference in Stellenbosch, that being Quackery and pseudoscience. And so, Janusz asked me on a very interesting topic. But I think I understand it because actually this weekend I decided that I really should sort of, lose a few kilos for the holidays. So I went into a well-known pharmaceutical chain, and I couldn't believe the number of food supplements that are on sale. Food replacements, weight loss guaranteed. I could have spent a fortune. But before I decided to spend any money, I thought perhaps I should get a legal opinion from you in terms of, what are the legal implications for these products? And so I've heard some discussions that there's not always safe or sound science behind it. And so I thought that perhaps you'd be able to give me some insight, especially after this this conference that you've recently presented at. So what are you going to tell us about my diet products today?
Well, there are many products out there which make all sorts of claims which are unsubstantiated, which are based in anecdote. My grandmother used to take it and she lived to be 103 type of anecdotes. And
Yes.
Those are the foundations of quackery and pseudoscience. There are obviously some products which actually do work and have scientific basis behind them. So I don't want to say everything that is on sale there is obviously fake, but one does have to be discerning before you lay out your hard-earned cash.
Absolutely. So now, as I understand it, we've always had this gray area with regards to food supplements. Are they medicine or are they food? And hopefully today's presentation is going to put a little bit more, emphasis on these things and explain to us exactly how the legal requirements address these products.
Sure. Look, I think let's just start off with a quick definition of what is pseudoscience and what is a quack. So pseudoscience, as the name tells you, it's not actually science. It's beliefs people have that they think are scientific. And a quack is a person who dishonestly claims to have special knowledge and skill in a field such as medicine. So just to get that behind us, what are we talking about when we talk about quackery and pseudoscience? And I think, yeah.
Continue.
I said, and to quote Carl Sagan, he said, he worries that especially as the millennium edges nearer, pseudoscience and superstition will seem year by year more tempting, the siren song of unreason more sonorous and attractive. And the reason is that scientific explanations can be very long and complicated, and people don't actually have the time or don't really want to hear them. They want an instant coffee answer to their problems.
Yes, absolutely. I'm thinking about how many days there are left to the holidays, and I definitely could do with one of those quick fix kind of things, those instant coffee solutions. Okay, so now let's talk about medicine and let's talk about food, because it's kind of a cross-border issue.
Sure. So just very briefly, as you'll see from the slide, that under the Medicines and Related Substances Act, there's a definition of medicine, and the important words are the ones I highlighted in red, which say, if something is purporting to be suitable for use or manufactured or sold for use in the treatment, diagnosis, mitigation, etc., of symptoms. So something which has no medical activity at all, to be blasé, let's say a bottle of water, which makes claims that it can cure something or treat something, is in fact a medicine. It's not a medicine because it's got any active ingredients. It's a medicine because it claims to be a medicine.
Okay, I understand. And that's now we get to the complementary food substances, and is it medicine or is it food? So how do you make sure that these products are actually, sort of policed?
Sure. So in terms of the Medicines and Related Substances Act, there's a requirement that medicines must be registered. And when you register medicine, you need to be able to show certain things in a dossier. The one is that the product is suitable for the purpose for which it is intended. So if you are making a claim that it will treat diabetes or boost immunity, whatever the claim is you're making, you must be able to prove that it's suitable and it will actually do that it will comply with the prescribed requirements of safety, and that is in fact safe and efficacious and of good quality. So all these products do need to have this registration if they comply with the definition of a medicine.
Okay. And if I look at how this is communicated to me as a consumer, how would I know?
Yeah, so under the Medicines and Related Substances Act, and more importantly, under the new recently passed regulations, which are a little bit further in the slide presentation, there's a requirement that the label of a product which is being sold as a medicine must have all the prescribed particulars on the label. And this is now a very big change from how it was before, because many of these complementary medicines in the past had very scant information and sometimes misleading information. Whereas now there will be a requirement that if you want to be a medicine, then you must be labeled as a medicine with all the information required for such a product. In terms of marketing of these products, there is currently in process a code of practice for the relevant fields of medicine, which is going to be brought into effect under Section 18C of this Act.
Okay, all right, but those are not as yet available.
They're not yet enforced. The organization called the Marketing Code Authority is currently negotiating with the Department of Health on the implementation thereof.
Okay. And in terms of this particular change in legislation and the enforcement of this legislation, we now start to see clearly defined what are considered foods and what are considered complementary medicines, or food with some medical claim. Sure.
So, I mean, I actually think, to be quite honest, this has been clear for a very long time, but, you know, people like to obfuscate things, and they try to create uncertainty where there really is none. It's quite clear that the Foodstuffs Act defines a food that it's everything you can eat except where it's a medicine, and medicine is defined as everything except where it's a food. So the two are mutually exclusive, and there are in fact only two categories.
Okay.
Complementary medicine, as the name says, is simply a type of medicine. And as you'll see in the further slides, under the new regulations, they've simply created a category D to cater for complementary medicines as a type of medicine, and it is by no means in any way related to foodstuffs. So there are not three classes of things. You don't get medicine, complementary medicine, and foodstuffs. You get foodstuffs and medicine, and complementary medicine and health supplements fall under medicine. So
in terms of the Foodstuffs Act, we've now got specific regulations regards to what we can and cannot get on food.
Sure. So the Foodstuffs Act and the regulations thereunder, the so-called R146, are quite clear. No health claims can be made in packaging or advertising, no functional claims, etc. The real difficulty is there's virtually no enforcement of this taking place, except when you're importing a product, because Port Health has now started intercepting imported products that don't comply with the regulations, for example, because they make claims.
Great. So at least somebody's doing something about it.
Yes, yes.
Okay. And in terms of the changes in the Medicine and Related Substances Act?
Sure. So first of all, the Medicines Control Council is going to be no more. It is being replaced by the South African Health Product Registration Authority, and immediately you can see the shift in emphasis. It's now going to be geared to cover all the various products which are considered health products. There are new health supplement and complementary medicines regulations as from 25 August 2017, which contain a definition of what is a health supplement, because that's another whole kettle of fish.
Yes, yes.
And it includes, of course, now a medicinal classification for products which are complementary medicines or health supplements. So briefly, health supplements, as you'll see in the next slide, I think, are in fact now considered to be complementary medicines.
Okay. So here we have the new definition.
So a complementary medicine, similar to the definition of a medicine, again uses this wording, which is used or purporting to be suitable for use or manufactured or sold for, and then what is that purpose? Maintaining, complementing, or assisting the physical or mental state, or diagnosing, treating, mitigating, modifying, etc., the abnormal physical or mental state of a human being or animal. So you can have a complementary medicine for your dog as well now. It's not just for humans.
Yes. Yes, no, I have arthritis medication or an arthritis sort of supplement for my dog. So yes, absolutely. And
this now will fall under this regulation. And a complementary medicine can be a health supplement, or put another way, a health supplement can be a complementary medicine. And sorry, there's a little thing on the screen in front of the bottom of the slide. In case, in accordance with the disciplines as set out by the authority. So what we're talking about there is Ayurvedic, allopathic, all of those types of disciplines.
Okay. Now this is, I mean, all vitamins, all of those kinds of, alternative therapies would now be covered by this particular piece of legislation.
Yes, of course. If they are purporting to be suitable for use or manufactured or sold for use of any of those purposes, and if they're made from any of plant, fungi, algae, seaweed, lichen, mineral, animal, or other substance, I think that covers everything on our planet. I'm not sure there's anything else.
I just wonder how many people know about this. So so a health supplement here, I see it has some nutritional effect. So my diet foods are coming into this discussion.
Yes, so there'll be many products that people have not thought of which claim a nutritional effect.
Yes.
Or which may have a nutritional effect. Remember again the words here: sold in dosage forms, used or purported for use in.
Yes. Yes.
And then when you start talking about nutritional effects, supplementing the diet, complementing the health. So these are all health supplements. Now, I get asked the question, but what about somebody who sells whey powder?
Yes.
Now, if you sell whey powder, but you don't purport that it's useful for anything, you simply sell it like you would sell sugar. You buy a 2.5 kilogram bag, and on the outside it says whey powder. I don't think it's a health supplement. It's just a foodstuff. Yeah. Where it becomes a health supplement is where you now say helps restore your muscles after exercise. Suddenly, you're no longer a foodstuff. Now you're a health supplement.
Absolutely, and all of those fantastical things, are obviously what would definitely impact on us buying something, because it's the fantastical results that we want.
No, absolutely. So it's now going to be controlled.
Sure. All right. So we've got categories of complementary medicine, or rather medicine is now classified into a number of categories.
Yeah, so medicine has been classified into A, B, and C categories since the year dot when the Medicines Act first came out. They've now added a D category, a fourth category.
Okay.
So they now make it very clear. Complementary medicine are just another category of medicine. They are not something else.
Yes.
And there they say that it will be classified in terms of the discipline in terms of which it's used, whether it's a health supplement, and then they've got the classes such as Ayurvedic, allopathic, Chinese medicine, Western herbal. They've got all of those. In the regulation.
Great. Okay.
This, of course, now leads to the requirement that you need to have the labeling. As I pointed out earlier, the Medicines Act says medicines must be labeled as prescribed, and here it's now prescribed. So in the case of complementary medicines, you have to say on the packaging, complementary medicine. If it's a health supplement, you must also state it's a health supplement. If it's not registered, you must state it's unregistered medicine, has not been evaluated by SAHPRA for its quality, safety, or intended use. And here's a very interesting one for all our GMO haters, is that if it contains 5% or more GMO, you now have to state on the product that it contains GMO. Now,
of course,
in my view, that's been a requirement since the Consumer Protection Act came out. But many medicinal products, including complementary medicines, use cornstarch as a carrier. And that cornstarch is more likely than not GMO. Which means that all the health products, quote unquote, will now also be labeled as containing GMO.
That's going to be an interesting debate all on its own, and one which we don't have enough. We don't have enough time for that. Some more labeling issues.
Yeah. So if you've got any, sometimes people produce products which are a mixture of a complementary medicine and a scheduled medicine. Then you have to highlight the fact that it contains some scheduled medicine. But then you have to provide some interesting information. You have to provide the proprietary name of the medicine, the registration number, the fact that it's registered under Act 101, the category of the medicine, the category under which the medicine falls, the dosage form of the medicine. Here comes a very important one. The approved name of each active ingredient. So not made up names, trade names. I remember once seeing an ingredient in a product, the ingredient's name was Slimulima.
Yes.
Which I presume is not a scientific name.
No.
And so somebody who reads that is none the wiser as to what he's actually consuming.
Yes.
Now, each active ingredient has to be named by its approved scientific name. You have to also say how much of it is in there. And you're going to rank it according to the active ingredients with the highest schedule in lettering, which is minimum legibility, etc. So it's the food stuff way of labeling. You label things from highest to lowest. You have to say how much and what it is.
Yes. So it can't. It can't contain, I don't know, Hoodia, for example, whatever the scientific name is, and then that's at the bottom of the list.
No, it can't be. But having said that, some medicines you do take in very, very small amounts. So of course. That's not necessarily the case. But yes, a consumer will be able to see immediately, hang on, this only contains a very little bit of whatever it is. Then you're going to have to name any preservatives that you're using. Any antioxidants. If you're using tartrazine, you're going to have to put the same warning as a foodstuff has for tartrazine.
Interesting.
So they're going the full information route. Very importantly, all of this information must be on the outer packaging. So when I'm walking through the discount and I pick up the box, I must be able to see all this information before I buy the product. I can't just open the container, pull out the fold-out leaflet, then realize, it contains GMOs and I don't eat GMOs.
Yes. Sure. That's a whole new look on medicine, actually, because for the most part, you don't get all of that information on the outside of a box of medicine. You would normally only get that on the insert.
Yeah, no, look, to be honest, I also think that people have not been applying the Consumer Protection Act correctly, because many pharmacies, etc., have a notice that says they don't take medicine and things back. But if I'm only able to determine what's in a product when I get it home and open the pack, you can't then tell me I can't return it if it's not what I wanted to take.
No, I have to agree with you.
Yeah, it's a problem. So this will actually help to resolve that issue. And then, very importantly, as a default, you can't have a whole lot of marketing schmuck on the packaging. You can only put non-regulated information with the permission of the authority. So if you read 10.4, it says the authority may authorize the inclusion on the label of the medicine of any special information that is not required by the regulation. So if something is not required, you're not entitled just to put it on. You have to get permission to put it on. So marketing things, I doubt, will be appearing on packaging.
Sure.
So this regulation is already effective from August 2017.
Okay.
Maybe somebody could challenge it, but no one has challenged it yet. Enforcement is starting. The Medicines Inspectorate are going to start and have already started inspecting some of the manufacturers of these products. And then finally, the Medicines Control Council has published notices warning of action against unregistered products. And they even published some current applications, but those were all obviously under the law before the new regulations.
Okay. Now, in terms of advertising?
Yeah, so moving away now from the regulated side, there's also the issue of advertising. So the Advertising Standards Authority is a self-regulating system. It's an independent body. It's got a code of practice in which for each type of product category, like medicines, it has its own rules of how you can and can't advertise it. One of the important things when it comes to pseudoscience is that it requires independent prior scientific substantiation of any claims made. So you can't start making a product on the basis of marketing information your supplier gave you, and then when you get challenged, then start digging around for scientific support. You're supposed to have that support before you run the ad.
Absolutely, absolutely.
Yeah. So,
okay, so we've had some activity from them in terms of this kind of medicine.
Yes, so there have been people that have complained against these medicines, and the ASA has decided on quite a number of these cases. And some of these companies then who were ruled against by the ASA decided to take the ASA to court. So they took the ASA to court, and initially it looked like those companies had the upper hand. They were winning in the courts against the ASA. The courts made findings such as the ASA can't make rulings on these products because they have no expertise. They fall under the Medicines Control Council. The companies aren't members of the ASA. But finally, in November of this year, the Supreme Court of Appeal in Bloemfontein came out and made a ruling, and that is the highest court in the land except for constitutional issues.
Yes.
And it said that although the ASA cannot make rulings against non-members, it can make rulings to its own members about non-members. So it can tell its members, don't run these advertisements because they contradict our code.
Yeah.
Even though the person who wants to run the ad is not a member.
Yes, yes, I understand.
Quite interesting that it seems that the ASA once again has jurisdiction to consider matters in food, scams, and supplements.
Okay, but that's good because, I mean, at the end of the day, if we've got that level of enforcement, at least that's something that's happening.
Sure. Then,
so as a consumer, if I don't lose the weight that my product has promised and I followed all the instructions, what can I do?
No, look, you could complain not so much about the product, but rather about its labeling, its advertising, how it's presented. Those are the issues you could raise with the ASA. The ASA is not going to look at whether or not you lost weight because of the ingredients as such, but rather what is being said on the packaging. Do they have scientific substantiation for what is being said? So a consumer can lodge a complaint at no cost and simply stand back and wait for the outcome of the complaint. If a competitor wants to lodge a complaint, however, they have to pay money to have the complaint heard.
Okay. Yeah. And there is a possibility of an appeal, and as you said,
so the advertiser who gets ruled against typically files an appeal and another appeal, and obviously they try to drag it out as long as possible, because as long as the process is running, they keep selling their product.
Yes, of course. But of course, what you're saying is the members could refuse to stock or even advertise the products that are now not complying with this, the requirements. So you could have the likes of Dis-Chem saying, we are no longer going to stock this product because it does not conform to the legal requirements.
Well, no, not there are two issues. The one, not conforming to legal requirements, this scheme should immediately stop selling the product. But it doesn't comply with the Advertising Standards Authority code. That's something different.
Yes. Okay. Right. So in terms of it's simpler than a court procedure, but it needs to be something that falls within the ambit of the ASA.
That's exactly right, yes.
Right.
ASA has often rejected complaints. The ASA has often rejected complaints on the basis that it doesn't fall within their scope.
Okay.
Yeah.
But so unfortunately, the Hong Kong websites, we can't sort of complain about those things.
No, so there are two issues with websites: company-owned websites, and foreign websites. Company-owned websites is a very interesting scenario because obviously, if I'm not a member and I run my own website, who are you going to complain to?
Yes.
Foreign websites are even more difficult because the ASA has no jurisdiction outside the borders of South Africa.
Of course.
So a company that advertises overseas but delivers to South Africa, very difficult. Nothing can be done about it under the ASA.
But what you're saying to consumers is if it claims to lose 10 kilos a day, it sounds unreasonable, unrealistic, unscientific. Proceed with caution.
Yeah, and lodge a complaint. It doesn't cost you anything to lodge a complaint.
Yes.
So absolutely. You lodge a complaint and you see how it shakes out, so to speak.
Absolutely. Okay, so the Marketing Code Authority, you mentioned this earlier. This is now something new?
Yeah, so the Marketing Code Authority has in fact been around for a very long time, but up to now, it's been a mechanism for resolving complaints between big pharmaceutical companies. So the one will complain about the other saying, you hosted 20 doctors on a cruise ship and gave them each a computer, and now that's why they prescribe your medicine, and we have an ethics code, and you shouldn't be doing this.
Okay.
The FCA has now expanded its scope, and they've moved into health supplements, complementary medicine, and dealing with consumer complaints on these products.
Okay.
So the big advantage of the MCA over the ASA, as I see it, is that the panel members are not actually employed by the MCA. Okay. They are, in fact, employees of the various companies that are members of the MCA. Okay. So they are scientific, they're technical people, they're able to evaluate technical things.
Yes.
So if you lodge a complaint, they'll pick out people that don't have a conflict of interest from other companies in the MCA, and they will consider the complaint.
Okay.
And up to now, they've been very even-handed. So there hasn't been a problem at all that there's any sort of conspiracy or anything like that. They look at it, bearing in mind that effectively they're ruling on a competitor's product. So if anything, it's likely to be worse, not better.
Yes, no, absolutely. Okay, so we can expect to hear from them sort of early 2018.
That's correct, yes.
And if all else fails, I still have the protection from the Consumer Commission.
You do, if you can actually get them to do something. But yes, on paper, they are in fact the strongest protection. If we can only get them to move on from the paper to actual real life enforcement. So the Consumer Protection Act is very good because it's got the right to information in plain and understandable language, so you can't bamboozle people. It has a prohibition on false, misleading, or deceptive representations, for example, claiming cures and remedies, weight loss, diabetes treatments for products which obviously aren't. It has a product labeling and trade description section, which deals with issues such as GM labeling. But another issue that could fall under that particular heading could be traditional medicines. Just lately, I've seen quite a few things that are pretending to be traditional medicines, and of course they're not. They are modern products made to chemical processes which are vaguely based on some notion of a traditional medicine from a long time ago.
Janusz, thank you so much for your time. That was really interesting. Ladies, those diet products, gents, those weight gain, muscle gain products. we should proceed with some caution. Make sure that you look on the labels, that you've got all this information. This is now law, it's nothing new. Suppliers are supposed to be conforming to these requirements. Make sure that there's sound science behind the claims, especially because these products are often very costly. For those of you that are using traditional medicines, please be aware that this is a regulated area, and you need to make sure that the claims that you are reading are in fact supported by science. So please share this on Facebook. We think that everybody needs to know about this, not just the manufacturers of these products, but those, of course, need to take note, because your labeling is definitely going to have to change. Thank you for joining us this afternoon. We trust that you found this useful and informative. We'd like to invite you to join our next webinar, where we'll be talking about the listeria crisis in South Africa. So please make sure you look out for those details and register. We love to have you on our webinars. Janusz, once again, thank you so much. We really appreciate your support. Thanks.